Yes, Jiten sir, we are starting.
Sir, please begin.
Huh?
Start.
Hello, I can start?
Sir, yes, please.
Okay. So, a very good afternoon to all the viewers. Myself, Dr. Rajesh Singh, Associate Professor, Parul Institute of Law, Parul University. First of all, I warm welcome our special guest, Sri Venkatesh, who is the Managing Director and founding partner of SKV Law Office. Pertaining to his specialization, he specializes in the infrastructure regulatory practice and has over 14 years of experience. After graduating from Amity Law, Delhi, affiliated to GGSIP University in 2008, he began his practice with renowned top tier from the Jyoti Sagar and Associate, and thereafter moved to HSA Advocate. In 2012, he branched out setup of SKV law offices, and since then he was steered the firm toward an impressive exponential growth. His solution-oriented work ethics and constituency in the deliberation with the redressal of the dispute and helped his emergence on one of the leading names in the commercial and regulatory dispute practices. He formed the practices areas ranges from the energy infrastructure, arbitration, consumer protection, disputes, environment insurance, and advisory in all aspects of the law. Apart from the above, in the regulatory, he regularly represents and advises the uh, natural uh, conglomerates in the dispute before the various high courts, tribunal commissions of the Supreme Court and commissions and the Supreme Court of India. So on this note, sir, I warm welcome you, myself, Dr. Rajesh Singh, on the behalf of sir. We have in the Parul Institute of Law, we have total around about 850 students who are pursuing their LLB and LLM programs. We have around about 55 to 60 students in the PhD programs with the different specialization. In LLM, we have 8 specialization with different categories. And secondly, sir, we have 5 years integrated programs and we have 3 year unitary programs at our institute level. So on this note, sir, I warm welcome you, and we will start our this session on the topic the effect of the change in the law and the force measure in the power sector. This is very important for all our because we have one CEP programs where the students are doing the this short term programs in the energy law. So, sir, on this note, I am handing this session to you so that our all the student will enlighten and we will and at the last 10 minutes we have the questions session, so the student will ask certain questions on the particular topic, sir. So over to you, sir.
Thank you very much for having me on this platform of yours, and I congratulate you on having this course specifically dedicated to energy laws, because this is something which is today we read about the power crisis in the newspapers every day, but very few law schools are looking at this and looking at this as a specific discipline to be taught in law school. So I congratulate you on that, and it's fantastic that you have this program. Now, on the topic for today, which we have chosen, is the effect of change in law and force majeure in power sector. So let me try and break this down to you as rudimentarily as I can. Power sector comprises of different entities engaged together to constitute the power market. There are generators, there are traders, there is distribution company who supplies powers to your homes and your offices and your colleges, and there are transmission companies which are used for the purposes of sending power from generating company to the distribution licensee. They are so-called the linkage between the generator and the end user. So these are the four or five broad entities which constitute as the major constituent of the power sector, and they are, of course, they all operate on different methods. But the be all and end all of all of this is that the end consumer, which is people like you and me who are using power in our homes and in our offices, end up paying for the entire value chain of generation, transmission, distribution. All of it gets covered in the tariff that we finally end up that we pay. And tariff itself is a dynamic concept. It is determined or discovered depending upon which route each entity has taken. So right at the generation level, there are two routes available for a project to be set up, which is cost plus tariff termination, where the actual cost of the generating company is factored by the regulatory commission and a tariff is as determined, or the competitive bidding, as we call it, the transparent competitive bidding, where generators, on the basis of their estimation of what the actual operating cost is going to be, place a bid, and on that basis they are selected and they develop power plants. That is the two methods which are available at the generation level. Similarly, at the transmission level also, there are two methods of tariff determination: cost plus and competitive bidding, because both of them are transmission licensee can come in under both mechanisms. But at distribution level, it is only cost plus, because no distribution company, the ultimate distributor, cannot bid on tariff. He has to be allowed reasonable recovery, because he is the last person in the value chain which recovers the money from the end consumer, which is you and me. So this concept of change in law affects all three levels: affects generation, affects transmission, affects distribution. Now, what is change in law is really the first part of the issue. Change in law is anything which positively or negatively affects the cost of running a generating power plant or a transmission system or a distribution business. So it could be, just for an example, GST. Now, goods and services tax was promulgated by the parliament in 2017, and within that, a lot of indirect taxes got subsumed, and a composite GST was notified. Now, this notification itself meant that some of these activities which were covered by different indirect taxes were now brought into a flat slab, which may have been higher than what the earlier indirect tax levied upon that goods or services was specified by the state government. So there could be a positive impact. Perhaps the GST number which applied to this particular item is much lower, or there could be a negative impact that the GST, revised GST, which applies to this item is much higher. Either which way, the entities in the power sector could not anticipate the promulgation of GST when that tariff was fixed. Now, before I go forward on change in law, I just want to dilate on a minute on what this tariff concept is. Tariff is something which is not defined under the Electricity Act. Tariff determination is defined, or rather specified, under clause section 62. Tariff adoption or discovery is defined under section 63. Tariff itself is not defined. Tariff is nothing but a formula by which the regulator comes and tells you that for you to recover your entire investment into this project of, let's say, 50, 100 megawatt thermal, hydro, renewable, solar, any project, you must make this rupees per unit. Ultimately, what is sold in the market or what is procured by us consumers is per unit of electricity. So tariff is determined also on per unit. This is on the basis of this determination takes place on the basis of your capital investment, as well as for thermal power plants, the operating investment that you have. For example, in a thermal power plant, there is a power plant which has a fixed cost and it also has a variable charge. Variable charge is the cost of coal. Now, all of it gets determined on the basis of the applicable taxes and duties on that particular date when the tariff is determined. Usually it's once in a year and it gets screwed up every 2 years. Every state has a different mechanism, but this is the broad principle that most states follow. So the tariff is one thing which is fixed by the commission on the basis of what was prevalent on the date when the tariff gets fixed. Similarly, tariff is discovered through competitive bidding on the basis of the applicable taxes and duties on that particular date when the bid had been called for. So either of the two mechanisms take into account the extent framework of laws applicable to a generator or transmission licensee. We're talking about broadly in the context of generating company and a transmission licensee. What this change in law does is that it enables the person who is affected by change in law to recover in addition to whatever tariff has been decided either through tariff determination or competitive bidding, the delta of the additional money which it is spending because of change in law. So now we've covered the issue of tariff. Tariff is fixed on a particular date basis the applicable regime. The moment that regime changes, and if there is a positive or a negative impact on that person whose tariff has been fixed or discovered, that person gets entitled to recover this money from its buyer. Now, the way the value chain works is that the generating company's buyer is a distribution licensee, who is the end supplier to us as end consumers. And the transmission licensee's end buyer could be a generator contractually or could be a distribution company, either one of the two. But the common parlance is that it is a distribution company. So the distribution company is the last leg of the entire chain. Therefore, the impact of change in law felt by the generating company or the transmission licensee, as ratified by the commission in question, the regulatory commission in question, is ultimately borne by the distribution licensee, who recovers this from end consumers like you and me. So, dilating back to what is change in law is nothing but an act of a state government or a central government or a parliament or a state legislature or any of these entities who are embroiled in becoming part of the value chain of electricity business. Once they change any parameter which affects the cost of running that business, any generation or transmission or distribution business also, then that gets added on top of the already determined tariff in simpler terms and is recovered from end consumers. So change in law is a method by which all risks which are beyond the control of the generator are passed on to the distribution company and the end consumers to ensure the longevity and continuity of these businesses, which is generation and transmission. That is the sum and substance of what is change in law. So that is how it works. Of course, there are complicated ways of doing this. For example, just I'll dilate for a minute on how this gets passed on. In a cost plus regime, there are something called regulations, which are framed by each regulatory commission, central or state. So change in law impact gets recognized and decided in periodic tariff orders, which are passed by the state commission or the central commission. And that basis that tariff order, the distribution company gets billed, and the distribution company basis its tariff order recovers that money from end consumer. So this is on the cost plus regime. This is how it happened. In a competitively bid project, it's slightly different, because it becomes a contractual matter. In a competitively bid project, there are no regulations. They don't apply to these projects, transmission or generation. So it becomes an issue of a contract. There, the concerned affected party invariably approaches what we call is the appropriate commission and seeks a rendition that please allow me to recover this money additionally because this has happened after my bid submission. The regulatory commission then allows it, and once it allows it, it gets passed on to the DISCOM, and the DISCOM recovers it from its end consumers. But over the last 14, 15 years, I think almost 20, 19 years, since the Electricity Act came into its being, there has been a realization that there is a huge time lag between when the change in law event takes place, when it is incurred by the affected party, and how it finally gets recovered in tariff from the end consumers. And this delay, because there is a decision required by the appropriate commission, there's a decision required by the state regulator on which the licensee operates, and how he recovers the money from his consumers. This delay, this 5-7 year gap which takes place on each event, invariably attracts interest on the principal liability, which is again recovered from end consumers. So you and me get burdened with interest because of the matter pending in the courts. Therefore, the central government in October of 2021 has come up with a called electricity change in law rules. And to simplify, what this rule does is it simplifies the whole process. The moment a person gets affected by change in law, he gives a notice to its contracting party. He immediately raises the bill. And if there is any dispute, then the dispute is brought before the commission. Otherwise, the other party can simply pay the money and recover from its end consumers. So to streamline the whole process, a rule has been promulgated by the central government in the hope that this whole process of how change in law is recovered and paid, that is streamlined. So that rule has only come in October of 2021. We are hopeful that that rule will be followed by everybody concerned, and there would be some, the so-called carrying cost impact would reduce substantially in years to come. So that is on the issue of change in law. Now, force majeure is a tangent to a infrastructure project. So what happens is infrastructure projects are inherently very large, very capital intensive by their very nature, generation or transmission or distribution, all of them. And because they are capital intensive, they require a host of approvals, sanctions, and land, and all of these ingredients are required to actually set up a power plant and run a power plant. For example, a thermal power plant requires land, requires forest clearance, requires environment clearance, requires pollution control board compliance, requires transmission system, requires a host of sort of items to make a power plant run. But the sector in its very inception realized, in fact, this used to happen under the old act also, that there are many aspects of a power plant which are inherently beyond the control of the person who's running that power plant or a transmission system. For example, you are connected, your coal in a thermal power plant is brought by railways. Railways are the end persons who drop the coal at your unloading point of your power plant. Now, this is connected through a mesh of rail network pan-India, from the coal mine right to your doorsteps. Now, within that, there may be a scenario where the rail line which is coming to your power plant is disturbed or is affected or is broken down. For that reason, coal does not reach your power plant. That is something completely beyond your control. Another example, there is a cyclone or a flood within your area, and that affects your ability to generate. So these are all, and your ability, your generation, or your ability to your requirement to generate and supply to your DISCOM is paramount, because DISCOM their electricity till now cannot be stored. Nobody has a storage system. Whatever is being generated by power plants across India on real-time basis is being consumed by end consumers in India. There is no warehousing of power. That is theoretically now possible, but that has not happened in India. So your contractual requirement to ensure that you are available and you are supplying power is paramount. And you cannot be remiss in that obligation to supply. But there may be instances where you, despite doing whatever you can, have not been able to supply. Your railway network got affected, for which you could not get coal to your power plant. Without coal, you can't generate anything. Your transmission line through which you are supplying power, that is affected by, let's say, a cyclone or a flood or something happens to it. And you're not able to, the power which goes from your power plant is not able to be received by the person who is buying from you. These are all events which are beyond your control. Then you are setting up a power plant and COVID happens. Wave 1 happened, wave 2 happened, where nobody could move across districts. There were 144s being imposed. And you have a strict timeline to finish your power project, but you can't finish it because there is, there are so many people, there are 144 restrictions imposed in different states, depending on the level of COVID-19, which is prevalent in that area. So these are challenges which are, of course, beyond your control. And to mitigate these challenges, there is a concept of force majeure which has been introduced. Now, force majeure, as you all understand, I'm sure you're students of law, is inherently specified under the Contract Act also, Section 32 and Section 56. 32 is on contingency of certain events, 56 is impossibility of performance. So even the Contract Act recognizes that a contracting party may be prevented to perform its obligations beyond what has been specified in interstate contract. Now, the development of law is started with Taylor versus Cladwell, 1861, and it is a judge-made jurisprudence from the British courts, and it has been adopted by our Contract Act to a certain extent, and now is validly recognized after pandemic, because pandemic was the first event where a host of companies and different contracts also invoke force majeure, let alone power contracts. And what it really does is that force majeure only, by and large, I mean, there are certain contracts where force majeure also entitles you to certain compensation, but by and large, the concept of force majeure is that it is a device by which you can be excused from performing your obligations. That is the conventional understanding of force majeure. That if you have an obligation to supply 100 units, and because your power plant's transmission line, which is not run by you, by a transmission company, it is being affected, you could be excused from your obligation to supply those 100 units, because it is for an event it is for an act of God which is beyond our control. So that is the conventional understanding of force majeure, that your obligation under a contract or in law could be excused for the reason that you were affected by an event which was completely beyond your control and is akin to an act of God. That is what in substance a force majeure provision means, and how it sort of works. So force majeure, fortunately, in this and change in law, both these concepts have been deliberated in a host of judgments in India and in the power sector. And the primary judgment that comes to mind is the energy watchdog judgment rendered by the Honorable Supreme Court in April of 2017, authored by Justice Rohinton Nariman. And that judgment laid down a few principles. One, on the issue of change in law, it did lay down that it is a contractual relief, and if an event which takes place after the bids were called in, this judgment is in the context of Section 63. If an event which occurs after the bids were called in affects financially the ability of a generator or a licensee, then relief for that event must be given, albeit that has to be agreed under the contract how the relief has to be given. That is the first principle. Of course, change in law and force majeure, change in law is purely a contractual relief or should be in the regulations. Force majeure is a contractual relief, but if there's an question of impossibility of performance, you have Contract Act available to you, because then you can relate to Contract Act and say that I can't perform this contract anymore. So this judgment decided two things. One, it said change in law applies in contracts. If there is a notification which falls within the meaning of change in law under the contract, you should be granted relief. So therefore, all domestic levies by the state, central government, authorities, etc., all of them are getting covered in change in law, and the impact of that is being passed on to the end consumers. That is the net effect of the Supreme Court judgment. And on force majeure, it said very simply that force majeure may also apply in a given case, but force majeure only grants you time. You can't really claim monies under force majeure unless the contract stipulates it in that fashion. In that given case, before the when the energy watchdog was decided, the court came to the finding that, look, the provision of the contract does not entitle you to any financial relief. Therefore, on force majeure, you will not be granted. So that is what they decided. And they said that if a contract provides for force majeure within its contours, then Section 56 under the Contract Act cannot be availed. That's the third tangent to it. Section 56 of the Indian Contract Act only comes in when there is no provision for force majeure within the contract. So the Supreme Court judgment, I would urge all of you who are listening to this and are interested in knowing a little bit more about change in law and force majeure, may consider reading this. It's a very well authored judgment. It's not very long, and you will find something meaningful there, and that will help you. So these are the broad issues that I can sum it up, which say that change in law is again a restitutory relief, where something which affects your operation of your power plant in any fashion, that will be passed on to you in terms of financial ramification. And force majeure conventionally excuses performance of your obligation because of an event beyond your control. The underlying theme of both are for actions which are beyond your control. In change in law, there is a financial injury to you, so you will recover that financial injury from your buyer. In force majeure, it is contractually decided. In most cases, there may not be any financial injury. Therefore, you may be excused from performing your obligations under the contract. So I think this is how I would cover most of it. And if there are any questions, I'm happy to answer.
Sir, it's for a very fine session. Sir, we have certain questions. In the contract, you have mentioned that that if suppose there is a contract has been made, and if let us suppose a power plant is set up and their projects are going on, and after the completion of the project, when they will start the project, they find that there is certain uh, there is an urgency that some act of God, and due to this, the power plant has certain problems. So, in that condition, sir, what are the major things which the power plant, while installing the power plant, the project manager has to look after in these particular things?
So, while setting up a power plant, power plants are supplying power on the basis of a contract. Of course, there are certain power plants which don't have contracts, and they are called merchant power plants. For them, all risks and rewards are with them. If they're able to sell power outside, they will make money. If they're not, they're not. If they can't, they can't. But this issue, what you said about facing a force majeure or some surprise or some difficulty, according to me, all of it gets taken care of in a well-drafted force majeure clause. When you sign a contract, so if you sign a contract, let's say through competitive bidding, these clauses are already part of the competitive bidding document. So you will get the benefit of that. But if you are signing a new contract without going under competitive bidding and the cost plus regime, there you will have to ensure that you incorporate these provisions, so that if you face a difficulty of a force majeure or change in law, you are able to recover this either in terms of time from the other side, or in terms of any financial injury in terms of the compensation from the other side. So it is how the contracts are drafted. So therefore, both concepts work very closely with the contractual provisions under which they operate.
Okay, sir. Sir, what are the major force major the in the electricity regulations is to be keep in the mind while installing the projects of any power plant?
See, major force majeure would be general conventional understanding of force majeure of any act of God, anything which is beyond your control. It could be act of God, cyclone, floods, fire,
Yeah.
rebellion, all of it. There could be compulsory acquisition of the company. That is one way of looking at it. Any
So
clearance at the
insurance can be provided in these conditions.
Yes, of course, power plants also have insurance. So it may also happen that you may suffer force majeure, and that force majeure is getting mitigated by the insurance that you've taken for your power plant. That can also happen. Correct.
Actually, in the high voltage and low voltage line means where there is a 11 kV, 11,000 volts lines are there, and where there are only 440 volts, because it is converted through the transformer. Because whenever the transmission is there, then it is a conversion from higher voltage to lower voltage, because the power plant will be generate the electricity, and the electricity will be transmitted through either 33 kV or either 11 kV. So, sir, what is your presumption that in these, no doubt there is a heavy cost on these. So, what the electricity board has to look after in these circumstances, that whenever they are transmitting, so as there are different charges from different states. Say for example, if I was talking about the Gujarat, we have the the three phase line charges are around about 11 or 12 rupees. But if I will go to the consumer, then it is 6 or 7 rupees. So, sir, how it varies that this will change the factor, because the rates are changing. If I will go to Himachal Pradesh, the rates are changed. If I will go to Punjab, the rates are changing. If I will go to Gujarat, the rates are changing. So, sir, what is the reason of this rate of change? Is there any regulation that there should be a common rate in all the state?
Actually, electricity is a concurrent subject where central government and state government both have a role to play. Each state government, under its jurisdiction, has a state commission. And on the basis of the capital investment in the transmission business or distribution business, the state commissions determine the cost plus tariff. So setting up a transmission system perhaps in Himachal Pradesh will cost a lot more compared to Gujarat because of the geographical location of how transmission system will operate in Himachal between mountains or in plains. So it is, and what you end up paying is a socialized cost of a host of things. One is the actual cost of setting up, the other is the cost of operating, the cost of procurement of power, the cost of efficiency, and the way how efficient your discom is. So all of it is socialized in the end time. So there are a myriad of factors which are governing each state, and on the basis of those factors, the regulator comes up with a final tariff, either 6 rupees, 10 rupees, or 20 rupees. So that is why it is different. It can't be the same because there is no, each state is determining tariff for its constituents, which is its discom, its transco, and therefore you're paying different tariffs in different areas.
Sir, in the pandemic situation, when this pandemic situation phase one, phase two was going on, so in these cases, in these the few peoples were taken out from the electricity boards also because of their less work. So in that situation, what is your opinion towards any provision that these should not be taken out and the electricity board should take care in these pandemic situations also, sir?
Actually, I don't think there are a few boards still existing. Most boards have unbundled into different companies, but the boards which are existing, like for example Himachal, they have their own employees. The board are Article 12 entities. So their employees have the protection of the constitution. If they have been fired, then they have to, that is a subject matter of a service dispute between them. There, as a power sector council, I don't have a specific view because that is not what we deal with here. But of course, well, as you rightly said, in pandemic, nobody should lose their job. And I don't think people have lost their job because electricity was an essential services and it continued to be throughout the period. So to my knowledge, I've not come across a state where there has been a mass layoff of any employees. And in boards, it's anyways not possible because they are government employees. And as
Yeah.
you're aware, there are constitutional safeguards to such employees. And they can't be given, unless they are temporary employees that are hired on contract basis, that will be a different scenario. But permanent employees don't face these problems.
Sir, secondly, sir, my last question is that, sir, in that it is beyond the topic, uh, that energy conservation is one of the important role in energy law, and electricity is very much important for everyone in the life of the human beings, because without electricity, everything is negligible. Now, sir, my presumption is that every industry is having the special power factor. They are improving their power factor. They are having a different generation plants. They are generating their own power right now. They are trying to avoid from the electricity board. They generate their own, or they set up their own power plant for the infrastructure so that their industry will develop more, and it is more cheaper also. But sir, in certain conditions, their skills are required more. But pertaining to energy conservation is concerned, what is your view that what are the major component they have to as a means in the energy law? What are the major things which have to be taken care in the energy law for energy conservation, sir?
See, energy conservation is governed by the BEE standards. So, as and when you are developing an infrastructure like a transmission system or a distribution system or a generation system, also, you are gravitating towards more efficient technology, which is inherent to it. But ultimately, the energy that you generate, transmit, and distribute, it all boils down to how efficient we are utilizing it. So all this, the value chain up to distribution company is moving towards energy efficiency because they have standards to meet and they're doing so. But it will not. But it ends at the power when it's distributed to your homes. How efficiently you're using this power entirely depends upon what your consumption pattern is. If you have old fridge lying in your house which are consuming that kind of power, or air conditioning which are non, I mean, now these newer ones are much more efficient, then you are bound to use more power. So the saving that you make out in the top part of the value chain is all lost out in the distribution business. So therefore, ultimately, energy efficiency can only be achieved when the entire country is moving to energy efficiency, and that is what we are doing. I think as and when how these energy efficient technologies are reaching parts of India, according to me, this trend will continue, and they will continue to get better.
Sir, it was a very fantastic session. We will not take more time, and you have elaborated in the starting that as per the section 656, and you have elaborated the contract, how the contract is to be made in this, and how this force measure will be applied, how this act of God will come in the picture, and what are the various aspect on the in the force measure. So on this note, now I will ask our dean, our director of CEP program, because under her guidelines, under her guideship, our program of this energy law is going on, sir. So I will just tell Dr. Kunjal Sinha ma'am to give a vote of thanks to our speaker, and then we will close our session. Kunjal Sinha ma'am. Hello, madam, are you there? Hello,
I'm there. Yes, sir, I'm
madam.
there.
Yes.
On behalf of Parul Institute of Law, and of course, the vertical in which from which I belong to, continuing education programs at Parul University, we would really thank you, sir, for taking out time and talking with our students on this platform to make them more aware about the working of the power sector. Just to brief you a bit, our vertical is into imparting skill-oriented short-term certificate programs, not only to Parul University students but to also students, outside Parul University. And with Faculty of Law, since last 1.5 years, we have come out with the certificate course on energy law. Of course, there are others also, but energy law is a special course because we have already run 2 batches of the course, and we see a lot of demand from the fraternity of people who are into law for further understanding the laws related to energy and the peripheral sector. On the same lines, when we were sitting with Rajesh sir, we thought that we should have something on power sector also, so that the candidates who are in our certificate courses as well as the students of our law faculty, they are able to get this complete idea about the working pattern related to law and the other guidelines. So once again, on behalf of Parul Institute of Law and Continuing Education Programs, Parul University, wholehearted thanks to you for sharing your views on power sector, and but most importantly, sparing your valuable time speaking with our students. Thank you so much, sir.
Thank you. Pleasure. Thank
And
you.
we are meeting on a virtual platform, but hope we meet in person also, because the kind of discussion students can have with experts like you in person will be altogether a different experience for them. So you're most welcome to our university whenever you find it convenient to
I'll try
visit
my
us.
best. Thank you.
Thank you, sir.
Thank you.
Thank you,
Thank you.
Rajesh.
Thank
Okay,
you.
sir. Okay, Venkatesh sir. Thanks a lot, and have a nice
Thank,
day. And
thank you. You
we
too.
will always means invite you, sir, because your knowledge and the you have a very big entire career in this electricity also. So you are dealing with lots of matter in energy law and electricity. So, sir, it is a great pleasure, and and you are the son of very renowned advocate, Mr. Vikas, sir. So it is a great pleasure, and I also find when your father will speak, I on he also speak on the force measure, but on the labor issue when this pandemic situation wave 1 and 2 was there.
Yeah.
So that was also a very fantastic session. So on this note, sir, we are very much thankful to you. So
Thank
on
you.
this note, we are closing this session. Oblige, sir.
Thank you. Thank you.
Oblige.
Thank you.
Thank you, ma'am. Dr. Kunjal Sinha, ma'am. Thanks a lot.
Thank you, sir.
Jiten sir, thanks a lot. Jiten sir, closing the session. Jiten Kubhani sir.